Good afternoon or good morning, California folks. It's good afternoon here on the East Coast, but it's 9:05 a.m. on the West Coast. This is the California call of the FFLGuard monthly variety. Happy to have you. Our leaders of the band out in California, Matt and Josh, are on with us. Matt is live streaming and Josh is camera off for COVID reasons, Omicron reasons. Well, thank you for joining us nevertheless, Josh, even though you are afflicted with this deadly Omicron. You'll be fine in like 48 hours, so don't worry. In any event, I had it and my kids had it and they didn't even know they had it. So yeah, everybody gets it. Oh, look at this, Chuck. No. Oh, hold on a second. As I live and breathe, Chuck Michele has joined us. That's how you know the California call has got real, when you see Chuck looking like Kilroy, just two eyes and a hat. All we need is your little hands like this, Chuck. There we go. There you are, Chucky. All right, Chuck, are you going to shot?
Probably for a day or two. You gonna be there?
Which day?
I live in Vegas. I can go whenever somebody's there.
Oh yeah, yeah, absolutely. I'm actually going with Lauren for this weekend, and then she's leaving, and I'm staying through the week.
Cool. Sounds like a seafood tower at some expensive restaurant on you.
On Sunday night
Yes.
when I arrive.
Yes. Okay, so let's stay in touch. But that being said, all of our California team is here, and there's a couple others from FFLGuard on the phone that I wanted to introduce to our California contingency who may not have been on the federal call. You know me, you know Brian, you know Avis over there. We know Hank Yasek. Hank is our business subject matter expert. Who you do not know is the handsome fella with the gray hair, Michael Franzak. Michael Franzak is our new ATF Director of Compliance. He was with ATF for 34 and a half years before coming over to us. He retired on December 31st and joined us shortly thereafter. He worked with many of the folks that FFLGuard clients already know, including Michael Bouchard, Jim Zamillo, and Rick Vasquez. Michael Franzak will be taking the place of Mr. Zamillo, who was with us for 10 years and will still be around as Yoda, you know, the all-knowing one that we can call on for historical perspective. But it was time to bring in young blood. Mike Franzak is our young blood. He was most recently a DIO in the Baltimore/Washington, D.C. Field Division. And for those of you who don't remember, the DIO is the head of the inspectors, or the IOI, and their area supervisors for 26 field offices, or fiefdoms, as I call them, Game of Thrones fiefdoms around the country. Michael last did that, but he has a wonderful resume of job positions, which, Mike, I will let you say hi and let you reacquaint this group with what you let the others know previously on what else you used to do over at ATF.
Sure. As Chris mentioned, DIO, Baltimore, Washington Field Divisions. So I covered two divisions. Political, a lot of politics involved in that area. But also I was the chief of the firearms and the explosives industry division in headquarters, ATF headquarters. I was an area supervisor in the field. I was a program manager at the ATF Field Operations Field Management Staff in DC. I was a special operations investigator when ATF used to have alcohol. We did a lot of alcohol diversion that went internationally, more so Canada, Europe, Asia. Also was a field inspector, as you all are quite well acquainted to during your FFL inspections.
And we're happy to have you, Mike. It's nice to have someone with new perspective, more current perspective. You spent a lot of time, and I would encourage everyone on this call who was not on the previous call to watch the video replay. We're not going to repeat all the material, but watch the video replay. Mike Franzak talks about how inspections are selected, how FFLs are selected for inspection using CGI analytics, prime gun, what does the I stand for? Interdiction? Prime gun? Intelligence, okay. Prime gun intelligence analytics. Mike also spoke a little bit about the 5 deadly sins, the Biden deadly sins. That are the 5.
Chipman. Slash Chipman.
Yeah, I guess prompted by, right?
Yep.
Powered by. So please do watch the replay of the federal call. It was literally an hour long. I think I saw some California people coming on at the end of our call. Please feel free to watch it and be informed. With that being said, we usually spend our time on the California call, letting our California team hone in on California specific issues. Chuck, since you have joined us today and you are the senior statesman, we'll let you go first and then hand it off to your merry men.
Well, I don't really have a whole lot. There's lawsuits working their way through the system. Our Duncan case, we got a bad en banc ruling. We are now asking the Supreme Court to hear that case, or actually first we asked the Ninth Circuit to stay it pending the ruling in the New York Carey case. And the Ninth Circuit has stayed a couple of other cases pending the ruling in the New York Carey case. So they have stayed the Duncan ruling for a short term. So we're hopeful they'll stay it, and then we'll get all this resolved under the ruling in the New York Carey case, which should change the standard of review and kind of be a hard reset on all these Second Amendment challenges. Other than that, I think Matt is going to have more to say about bills that have been introduced, and the one other lawsuit that has been filed is a challenge to the law signed last year that gives the Berkeley Research Center access to firearm records for their studies. I'm frankly not particularly optimistic about that lawsuit. We're not handling it, but there are some protections built into that. Actually, Matt will be doing some memos. We'll be putting out some memos on this, explaining exactly what that bill does and doesn't do. There's a lot of misunderstandings about how far it goes and what kind of protections it has built into it. So, we'll just have to see where that lawsuit goes. In the meantime, that law is in effect. So I think Matt can probably talk about that a bit more, and also about pending laws and some of the new laws for this year.
Are you handing off to me, Chuck, or is there?
Yeah, go ahead.
Okay. Well, real quick, before we get into the pending bills, I wanted to touch base on some stuff that's already been enacted and it's upcoming soon. The big one, of course, that's going to be affecting most dealers that are involved in the sale or transfer of what California now defines as firearm precursor parts is, of course, starting to take effect, or should take effect, on July 1st of this year. But of course, as I've mentioned in previous calls, we still do not have a definition under California regulations from the Department of Justice as to what constitutes a firearm precursor part. And DOJ does have to adopt regulations to define that term and sort of provide guidance to dealers on when something is not a firearm precursor part that would require, for example, a license, either having a California firearms dealer's license, or if they're not selling firearms, a specific firearm precursor part vendor license, which will also be available. As I mentioned before, the system is supposed to be just like ammunition sales, at least according to the laws that I've seen them as they've been enacted. So expect a sort of sale transfer scheme very similar to that, if not identical to the ammunition sales restrictions. But as I mentioned, we still don't know what this encompasses. And frankly, the DOJ has been dragging its feet, and unsurprisingly, because it's very, very difficult, I'd say practically impossible, from any sort of reasonable sense to actually define what these things are, because they're not firearms. And so potentially anything could be subject to those restrictions. And so finding a very clear definitive line is what I think DOJ is having a hard time doing, which is why we haven't seen any regulations on that front. As far as some other issues are concerned, I wanted to call to everyone's attention that if you have not seen it already, we did recently put out a very detailed analysis and sort of step-by-step guide as to what is or is not considered an assault weapon. That is something that should be available through the FFLGuard website, as well as the CRPA website. If you guys want to direct your customers or anyone else to that information, it should be the definitive end all be all. Here's what is or is not an assault weapon, just to help everyone understand that, because obviously the laws have changed, especially now with the recent changes for other firearms. As far as that issue is concerned, also, we have upcoming here this week, actually on the 13th, so Thursday, the DOJ is supposed to be reopening its registration period for bullet button assault weapons for people that were unable to register them. And so that's something that if your customers are asking questions about that, I'm hoping to, once we have an actual understanding of what the application looks like and what some of the details are, potentially have some more detailed information that you can share with customers as far as what they need to do if they are subject to that re-registration period that's opening here in the next few days. As far as more recent issues that specifically through DES, there was an important notice that was recently issued regarding the new requirements for Senate Bill 715, specifically for basically private party transfers, where both it's determined that both the buyer and then the subsequent return attempt to the seller resulted in denial. This provision is basically going to be sort of providing an option instead of immediately surrendering the gun to a law enforcement agency. At that point, it's now creating an option for a dealer relinquishment option, basically where you as the dealer can opt in these situations to purchase the firearm from the individual from the owner in that case, because it obviously cannot lawfully be returned to them. I'm going to have to be looking at this in more detail and some specifics about this. So just know that obviously you probably have all seen this now because it did come out through DES just a few days ago, and we will be providing more information on that. The same goes for the recent proposals as far as legislative proposals. Of course, the big one, Governor Newsom is trying to make do on his prior threat regarding liability issues for dealers and manufacturers that potentially run afoul of California laws, and by creating a civil right of action to that. We will be looking at that in more detail. And of course, it's just a proposal at this point, so it's not the law yet. And so we'll be seeing how that develops over the course of this upcoming legislative session. So with that, that's all I had to talk about. Josh, did you want to address anything?
Yeah, I've had a lot more I wanted to address, but as you guys can tell and heard from the top of the hour, I'm dealing with COVID right now, so I'm going to keep my remarks a little shorter than intended. I did want to let all of the folks there know about new laws that were taking effect in terms of corporate and employment issues. I think for today, I'm going to focus just on one law, and the one law is specifically the California Consumer Privacy Act. And so briefly what that is was in 2018, they passed a law here in California requiring certain collectors of consumer information, mostly businesses, including retail businesses like FFLs, to put into place procedures so that people who had given their information to the businesses had a way to know which information had been collected by the business and to ask the business to stop using or destroy that information. And the California Consumer Privacy Act was modeled in great part on a European law called the GDPR. There was a subsequent proposition that the fine voters of California passed in 2020, called the California Privacy Act. California Privacy Rights Act, and it made the California Consumer Privacy Act even more robust. They got rid of a safe harbor provision for businesses to fix their consumer information collection policies. It created a whole new bureaucracy in California, the California Consumer Privacy Commission, and as you folks who run FFLs know, there's nothing ever bad that happens when they create a whole new regulatory scheme.
Yeah.
So for FFLs out there, here's sort of the first step you need to go through to figure out what obligations you have. And this is going to be on the consumer side. I'm going to talk a second about the employer side, because although it's called the Consumer Privacy Act, it actually applies both in the context of dealing with your customers as well as your employees. So we're going to talk about the consumer, your customer side first. Understand that the Consumer Privacy Act's requirements for handling of consumer information only apply to businesses that meet one of these three criteria. One is that you do over $25 million a year in revenue. So if you do under 25 million in revenue, you don't qualify on that basis. You have to derive at least 50% of your income from selling consumer information, so marketing. So again, for most of the FFLs in here that are YSP members, they're not doing, half their business model is not selling the consumer information that they collect as part of selling firearms. The majority of your business is going to be actually selling the firearms themselves. So you're not going to qualify under that prong. The third prong is where you will probably comply. And the third prong, or I shouldn't say probably, maybe comply. If you collect more than 50,000 individual consumers' information, you're obligated to comply with California's Consumer Privacy Act. And so what that means is if you collect any individual consumer information, so that can be emails, that can be IP addresses, that can be gross information. What constitutes the collection of consumer information is very undefined at this point, because although there is a regulatory scheme, they haven't promulgated much in the way of regulations. And the language of the law itself is very broad. So you should assume that if you're collecting any information, including individually identifiable information for people visiting a website or sending an email, that's going to be sufficient to count towards that 50,000 consumer number. So if you look at all your DROS transactions, or you look at your DROS transactions plus your email signups on your webpage, and that number goes over 50,000, then you're going to be obligated to be complying with the consumer portions of the Consumer Privacy Act. So what does that require you to do? Well, it requires you, starting this year, to begin creating systems to allow you to track the information you are collecting and to be able to refer to it if you get inquiries from individual consumers about what information of theirs that you have. So it means you're going to have to start setting up databases that track, let's say you take consumer email information. You're going to have a database somewhere that allows you to look up all the emails you collect, because if you get a inquiry from John Smith, you need to be able to tell John Smith, yes, we do collect email information. We do have your email information, and if you've requested it, we will purge your email information from our databases and systems. The other thing it requires you to do is, for those of you that have an online presence, have a website, you need to have a statement on your website that identifies what information you collect and what you do with that information. And if anybody wants an example of what one of these statements looks like, feel free through the help desk to get a hold of us, and we'll get you some samples to take a look at. But you are now obligated to essentially provide notice to consumers about what information of theirs you will be collecting if they visit your website. So there are some record keeping requirements now that you're obligated to undertake, and you're not obligated at this point to disclose to consumers what information you have if they ask for it, but you are obligated at this point to start tracking that information. And beginning on January 1st of 2023, so beginning of next year, then you will have the obligation, if John Smith calls you up or sends you an email or sends you a letter, to identify what information of his you have kept, and then follow his instructions with regard to whether or not you must purge that information, or if there are other restrictions on the use of that information. It puts a lot of power into the hands of consumers, and in particular, and I think more germanely, consumer attorneys to dictate to businesses where they are violating the law, and how they can financially remunerate folks who have been horribly injured by your violations of consumer law regarding handling their information. Where you've seen lawsuits under Prop 65, where you've seen these ADA lawsuits either for physical access or website access, you're going to now start seeing lawsuits about violations of the California Consumer Privacy Act. So it's important that you guys start complying with this law, because the main way you're really going to see it enforced is through these shakedown lawsuits that you've seen with some of these other public protection acts, ostensible public protection acts that also happen to provide full employment to the trial lobby. So that's one side of the analysis. The second side of the analysis is the CCPA, the Consumer Privacy Act, as I said before, also applies to you and your role as employers, which doesn't seem to make much sense from a Consumer Protection Act, but makes sense from a standpoint of creating more headaches for you guys. It applies to you as employers regardless of how many consumer records you get, how much revenue you make, any of the other factors that apply to the consumer information side. So whereas before you might not have qualified for having to comply with the consumer records requirement because you don't do 25 million a year in business, you don't derive half of your income from selling consumer information, and you haven't collected at least 50,000 identifiable California consumer records. As a California employer, you are from record one, employee one, required to comply with the employer-employee obligations under the CCPA. And what those are is you have to give notice to your employees in writing of what information you collect from them that is considered private identifiable information. So that would be things like name, social security number, address, and what you do with that information. This is going to be a much easier task for you folks than on the consumer side, because you are sitting there right now thinking to yourself, well, I know what information I collect. I collect their social security number so I can do a work eligibility a check and make sure that I get money deposited to their SDI and social security and all those accounts properly. I collect their address so I know where to mail their last paycheck. I collect their name. And so it's real easy to write out the notice to your employees that you have to give them in writing as to what you do with their information. You just simply put down exactly what I just said, which is I collect your name so I know your name, and I can issue you a paycheck in the correct way, and I collect your address for the same reason, and I collect your social security number for the same reason, and and so on and so forth. But you got to put it in writing and give it to your employees, even though it's obvious to you, to me, to them, to the fly on the wall. Nonetheless, this is the employee protection aspect of this law that is sure to benefit everybody. The other thing you have to do is if there is any other type of information you collect, such as, for example, if you've got key card access to your business and you keep any kind of record of who is using key card access, which is pretty common. You want to know that your employee Joe, he's the one who used the key card on Monday at 6:30 a.m. And again, he used it at 7:52. And then on Tuesday, you keep that kind of information just so you know who's getting in and out of your business. You are going to have some way to be able to search that information and provide it to the employee if they ask. So similar to consumers, employees are going to be able to ask, which of my information do you have? Now, they can't ask you to purge it, because to the extent you need it, like you need their social security number to continue to be able to pay them and make sure that the withholdings are going into the right accounts. They can't demand you purge it, but they can demand that you let them know what information you have. So if you are keeping information like key card access or any other information, you're going to have to figure out a way to search it. Like I said, this is going to be a much easier burden for you from an employer side than it is from a retailer side with consumers.
Could you say that again?
Sorry, my watch got excited there. That's going to be a lot easier burden for you guys from the employer side, simply because most of the information that you'll need to be able to access is going to be in your employee personnel files. So with the exception of stuff like maybe key card access, all that other information that you would be obligated to identify if your employee said, well, what information do you have on me right now? You could go right into your personnel record and go, well, we have your name, we have your address, we have your social security number, we have a copy of your I-9, and it's all going to be in there. There may be some things that aren't, because you don't necessarily segregate that out by employee. Like I said, key card access information is one. Time card information is another, but again, time card information is really easy because that is usually going to be very easily sortable by employee. But this obligation with regard to employee information, notices to employees about what information you're collecting, and ability to respond to employee inquiries about what information you have on hand, that's an immediate requirement. And again, it's without regard to any of those factors that may not apply to you for purposes of keeping and responding about consumer information. So just bear in mind that's something you guys should be doing right now. And the notice, like I said, the notice to employees is a very easy one to put together. It's something that you should be able to put together and just stick it in your employee's next paycheck. Make sure that you've documented that you've provided a copy of the notice of what information you're collecting, and you should be good on that. I do not anticipate you're going to see much in the way of CCPA employee information lawsuits of the scope or scale that I anticipate seeing the CCPA consumer information lawsuits. If you do see the CCPA employee lawsuits, they're probably going to be tacked on to other wage and hour claims that an employee would otherwise be bringing. So we may see these types of CCPA claims in a lawsuit as sort of what I'll call a throwaway cause of action, something that's added on to what is considered a more substantive, failure to pay wages, failure to give rest periods, that type of lawsuit. I don't see it being a big moneymaker or something that ends up driving litigation. So, and then one final thing before I go. Of late, we've become aware that with some of the lack of knowledge about the CCPA and its application, as well as some of the confusion about how it applies and to whom it applies, we have seen some things going around the internet, such as phishing requests, where people are asking businesses to provide information about what their CCPA policy is and what information you would give. Right now, you don't have an obligation to respond to those. And more importantly, what we've seen seems to be more along the lines of like internet attempt to steal the identity information, not bona fide attempts to use the CCPA law either to make money for a law firm or because there's some gadfly consumer out there trying to make money. So anyways, that's all I have. Thank you for listening to me do my Henry Kissinger impression. And, you know, if you have any questions, feel free to submit them through the help desk.
Did you see the question in the chat box there? I wasn't listening for a second. I didn't know if you addressed it, Josh.
I didn't. I'm on my phone though, so I'm just proud that I was able to get on this Zoom call. Unfortunately I can't see the chat box.
It says we meet the threshold of being regulated. How do we balance regulatory requirements of data retention compared with consumer privacy data regulations?
Well, okay. So the bottom line is you have to obviously maintain the data, particularly you know, for purposes of complying with your obligations as a licensee of the DOJ and as a licensee of ATF. You cannot, if as a matter of law you can't purge the data, you don't purge the data. So if you got a inquiry in 2023 and they said, you know, what information do you have on me? By the way, I bought a gun from you guys sometime in 2022, and you go, well, we have your gross information, we have a copy of your driver's license, and and they said, well, I want you to destroy all that. Under the CCPA, you're not obligated to destroy that, even though the consumer has requested it, because under state and federal law, you're obligated to keep it for a different reason. So you're not obligated to destroy any information that by another law you're obligated to keep. You are only obligated to destroy that information that you're not obligated to keep. So for example, if as part of handling a DROS, you also happen to take down somebody's email address, which you may or may not later use for marketing purposes, and they said, destroy all my information, and you said, well, you know, politely, we can't destroy this stuff in your DROS record, you know, we can't destroy the copy of the driver's license, we can't do any of that because we're obligated to keep that. If you're not obligated to keep an email address that you have segregated for purposes of marketing, so you would be obligated if requested by the consumer to destroy that email address. But again, anything that is obligated to be kept by a different law, you have to keep.
Anyone else like to chime in from the California team? Otherwise, we will call it an afternoon, and we will post this video with also posting of the federal video, which I encourage anyone who wasn't on the federal call to watch. We will also attach, Avis, what are you going to attach to this one?
So far, we've got the assault weapons guide, the stay in Duncan, and newsroom proposal creating private rights of action.
Those will be attached to the posting of the video. We appreciate you joining us. Of course, if you have any questions, you can fire them to the help desk. We welcome Michael Franzak to the team. Hank, I don't know if you have anything for Californians that you didn't have for the rest of the country earlier. If not,
just make sure you buy your gun locks that you buy your shows this year. Make sure you got plenty of ways to secure guns based on the DOJ letter.
And that was all. That's information we covered in the federal call about the DOJ letter saying you better have your storage and safety requirements met. We will reconvene in February on the 7th at noon Eastern, 9 a.m. Pacific. And if you need me, you know where to find me. Thanks.
See you all at SHOT Show.
We'll see you at SHOT.